Hey guys, welcome back to another new videos and LawGuru welcomes you. So today in this video we will discuss complaint and investigation. In the last video we have discussed about police report and charge. So before starting this video, if you have not subscribed my channel, please go subscribe so that you all get CRPC related videos regularly. So let's start this video. First of all, we will discuss or know what is complaint under Criminal Procedure Code. Complaint means any allegation made orally or in writing to a magistrate with a view to his taking action under this code that some person, whether known or unknown, has committed an offense, but it does not include a police report. Now what it means? It means complaint is any allegation or accusation made orally or in writing against any person which is known or unknown to a magistrate. You are giving any complaint or making allegation against any person in orally or in writing to a magistrate with a view that after taking or after hearing that complaint or after reading that complaint, magistrate will take action under this code that some person, whether known or unknown, has committed an offense, but it will not include a police report. Allegation against a person, oral or written, constitutes a complaint. No particular form is necessary to constitute a complaint. As a matter of fact, a letter or even a telegram may be treated as a complaint. It contains or discloses facts. If it contains facts about an offense, constituting an offense, then that letter or that telegram will also be treated as a complaint. Whatever may be the document, it must contain an allegation which constitutes the offense. Then that particular document will be treated as a complaint. It is, however, not necessary that a complainant should verbatim reproduce in the body of his complaint all the ingredients of the offense he is alleging against the accused. It is not necessary that a complainant who is filing or who is giving the information orally or in writing, that person, it is not necessary that particular person should reproduce all the ingredients of the offense he is alleging against the accused. If the offense is theft, it is not necessary that the person who is complaining should write or produce all the ingredients of theft in his complaint. It has been held in Muhammad Yusuf and Afaq Jahan 2006 1 SCC 627. If you want to note down this case, you can. In this case, what happens? In this case, a petition addressed to the magistrate containing an allegation that an offense has been committed. In this petition or in this case, a petition is addressed to the magistrate. What it contains? It contains an allegation or accusation that an offense has been committed. And after all these details, there is a prayer. In the last or in the ending, there is a prayer that the culprit be suitably dealt with. This whole document is called a complaint within the meaning of section 2 clause D. Now we will discuss what is investigation under Criminal Procedure Code. I hope the part of complaint is clear to you. If you have any doubt in that part, please do comment. Now we will discuss investigation. As per section 2 clause H of the Criminal Procedure Code, investigation includes all the proceedings under this code for the collection of evidence conducted by a police officer or by any person other than a magistrate who is authorized by a magistrate in this behalf. Section 2 clause H of the Criminal Procedure Code deals with the definition of investigation. What this section says? This section says investigation includes all the proceedings, all the process under this code for the collection of evidence. The main objective of investigation is the collection of evidence. Who conducts investigation? The investigation is conducted by a police officer or by any person who is authorized by a magistrate in his behalf. Magistrate himself will not investigate and collect the evidence. He will authorize someone else to investigate on his behalf. There is a case HN Rishbhat versus State of Delhi, AIR 1955 SC 196. In this case, there are some steps of investigation given. What are the steps? The steps are: first, proceeding to the spot. For investigation, the investigating officer must proceed to the spot firstly. Second, ascertainment of the facts and circumstances of the case. Knowing the facts or what happened, knowing the event and the circumstance of the case. Third, discovery and arrest of the suspected offender. If the investigation officer or the police thinks that that particular person A or B is suspected, that particular A or B has committed the offense, then that police officer can arrest them. Fourth, collection of evidence relating to the commission of offense, which may consist of: first, the examination of various persons. If the offense is committed in a public place, if A has murdered B in a public place, and people who have seen committing that offense or seen that murderer, then all the people who have seen, they are the witness, their statements will be reduced into writing, and the person, if the accused is arrested, then his statement will also be reduced or recorded in writing if the officer thinks fits. B. The search of place or seizure of things considered necessary for the investigation and to be produced at the trial. The search of the investigation spot or the crime spot and the seizure of things. It may be the seizure of the weapon of crime or any blood stains, the collection of blood stains, blood drops, etc. These are all the evidences, or like search of place, searching the place, and seizure for the things considered necessary for the investigation, and these all evidences will be produced at the time of trial. And lastly, formation of the opinion as to whether on the material collected there is a case to place the accused before a magistrate for trial, and if so, taking the necessary steps for the same by filling of a charge sheet under section 173. Now last step is that if the police officer thinks by collecting all the evidences that there should be a case or the case should be placed before the magistrate for trial, if he thinks so by the evidence collected, and then what will he do? He will fill up the charge sheet under section 173. Arrest is the part of a process of investigation. Okay, while investigation, the police can arrest. Adri Dharan versus State of West Bengal, 2005 4 SCC 303. There is a case on this. I hope this video is clear to you. If you have any doubt in this, please do comment. And if you like this video, press the like button, share it, subscribe for more such videos. For then, stay safe. Thank you.